Hello and welcome to today's edition of our Political Economy Seminar series. In this seminar today, we will discuss the evolving politics of data protection regulation in India. Specifically, the artifact that we are focused on is the data protection bill that is currently in the parliament. As you may know, the bill has been in the works since 2017 when a committee was constituted to work on it. The committee came up with a draft bill in 2018, which was modified by the Ministry of Electronics and Information Technology and then introduced in the parliament in 2019. Now, 2 years later, a joint parliamentary committee has suggested certain changes to the bill. So the discussion for today is about why the changes have happened, what changes have happened in the bill, first at the level of the ministry and then as suggested by the joint parliamentary committee. And specifically the politics of these changes, what is the political economy that is shaping this bill as it moves in the parliament. So this discussion we will do in two parts. First, my colleague Anirudh Burman, who is a fellow and associate research director at Carnegie India, will make a presentation. I will then have a conversation with Anirudh, and then towards the end we will have some questions and comments from audience. And as we are going through the discussion, you are free to enter the comments in the comment box. If you're watching on YouTube and other channels, you can enter the comments there as well. We'll get those comments and we'll read them out and we will answer the questions as well. I now invite Anirudh to make his presentation.
Thanks, Suyash, and it's nice to have this discussion. A lot has happened in the data protection bill over the last 3-4 years, and it's a good moment to take stock because the report of the JPC is out. And just to be clear, the recommendations of the report are not binding on the government, but this has been worked on by a committee that was consisting of both government members and opposition members. So the government will take this seriously into consideration, but the government is free to accept either all recommendations or reject all of them or accept only some of them as it wants, and then have a discussion on the bill in the parliament. So what I'm going to do very quickly over the next 10-15 minutes is to give you a broad overview of what has happened in terms of the different milestones of the bill and the process it has gone through, and also some of the key changes that have taken place and what it reflects about the political process and the larger political economy of this issue of data protection and privacy in India. So in terms of the key milestones, there's been a lot written and talked about the need for a privacy law for a long time in India. There was a 2011 committee also set up that published a privacy report. But the more immediate impetus for this bill actually started with the judgment on privacy. And at around the same time in 2017, a committee of experts headed by Justice B.N. Krishna was constituted to look into this issue of data protection framework for India. And in 2018, they put out a report recommending that there should be a comprehensive data protection law. And they published a draft data protection bill, which was then circulated widely. At around the same time as the committee was constituted, there was a landmark judgment on the right to privacy in August 2017, within a month of the committee being constituted. And this came on the heels of a fairly long protracted litigation on the constitutionality of Aadhaar, the biometric identification scheme. And the Supreme Court felt that it had to decide whether there is an existing right to privacy under the Indian Constitution before it could actually give a judgment on Aadhaar. And in this judgment in August 2017, it said that there is a right to privacy under Articles 14, 19, and 21 of the Constitution. And it extended the idea of privacy both to state and non-state entities. So both of these were supposed to be covered by this notion of privacy, and citizens had a right to privacy against activities of both state and non-state entities. In July 2018, the Sri Krishna Committee submitted its report, and then the Ministry of Electronics and Information Technology put out this version of the bill for public comments. This process went on for a year. The ministry solicited comments, and then in December 2019, around 2 years ago, a little more than 2 years ago, the government introduced its own version of the Personal Data Protection Bill in Parliament, and it was referred to a Joint Parliamentary Committee. And then earlier in December 2021, about 2 months ago, the JPC tabled its report in Parliament. So just to give a bit of background on how things have changed, when the Sri Krishna Committee was constituted, the larger context of this idea of privacy and data protection was around the issue of Aadhaar and the use of Aadhaar for social welfare purposes, but also other like national security purposes and so on. And the fear was that Aadhaar's use would become so ubiquitous that it would become very easy for the state to misuse Aadhaar or the data collected by the use of Aadhaar. And that formed a large part of this discussion and debate around the right to privacy. So there was the immediate context for this data privacy law and the litigation in the Supreme Court was the suspicion of state power in the digital domain. And one of the main aims for demanding the law was to actually have a check on the misuse of this power, mostly by the state, but also by private entities who were using Aadhaar to collect data. So this was the larger backdrop in which this whole idea of a data protection law for India was thought about. And the committee proposed a fairly comprehensive legal framework for data protection. This is also on the lines of what the European Union has, what some other jurisdictions in the world have. So it introduced the idea of saying that data cannot be collected without giving some kind of a notice to individuals and taking their consent. And businesses who collect data and analyze it and process it, who are called data fiduciaries, were subjected to a number of new obligations in India that they did not have to comply with before, about how to store data, how to use data only for very specific purposes that they had actually taken permission for. They had to implement things like privacy by design in their entire business model. They're required to conduct periodic audits, impact assessments. If any data breach occurred, they were supposed to notify this data protection authority if they feared that the breach would actually harm data principals. At the same time, consumers or data principals had new rights. One was the right to access data, then there were rights to correct data. There was also a right to data portability, which meant you could take your data from one service provider to another for the payment of a fee. The committee also said that you have to localize or store Indian data within India if the data is extremely sensitive or of a critical nature. So it introduced this idea of data localization. And at the same time, there were some exemptions for the state for specified purposes, for legal proceedings, for law enforcement, for any judicial proceedings, and so on. These exemptions were limited. There was no blanket exemption to law enforcement agencies or the judiciary and so on. There were very limited exemptions for very specific parts of the bill. And at the same time, the bill also recommended the creation of a completely new, very powerful cross-sectoral data protection authority. And this was a big leap because this would arguably create a most powerful data regulator or a sectoral regulator in India. And lastly, there were heavy penalties that were proposed, and including criminal offenses and so on. So the focus in this committee was largely on the protection of personal data and from the perspective of individual privacy and autonomy. And there was no mention of non-personal data here. And the idea was that this idea of individual privacy could be furthered by putting obligations on businesses and government agencies. And the net effect of this would have been to actually create a lot of new compliances for businesses, and there were some exemptions given to the state. This changed in many ways when the government introduced its own version of the bill. Some of the obligations and penalties were rationalized because it was felt that the compliance burden was too heavy, but a number of new ideas were also introduced. So there was this idea of social media intermediaries, which was a class of data fiduciaries or data collecting businesses who were basically social media entities. It introduced the idea of verifying identity of individuals who were on social media platforms. It proposed the idea of differential regulation between small or regular data companies and large data processing companies. And it stated that some obligations like impact assessments and so on would only have to be done by this class of significant data fiduciaries. Then it introduced some provisions for looking at the treatment of how to process children's data, and it proposed an idea of guardian data fiduciaries. A significant change that happened in this version of the bill was that the limited exemptions that were given for government purposes were actually broadened for specific purposes. And a blanket exemption was given, or the bill gives the central government the power to give blanket exemptions to its agencies for the purposes of protecting the sovereignty and integrity of India, national security, and relations with foreign states. So this was a completely new and very broad exemption that was a major shift in approach from the previous version of the bill. And there was also this new power to the central government that gave it the power to mandate handing over non-personal data from businesses. But it did not clarify whether businesses would be compensated, what kinds of checks and balances would operate here, and so on. And at the same time, there was some dilution of data localization requirements. So you can see some areas there were some rationalization of compliances, but there were also areas in which state power was increased significantly. And then we come to the JPC recommendation. And the JPC report took 2 years to prepare. The report mentions that there were more than 78 sittings of the members of parliament, and they've done a very thorough consultative process as per the report itself. But there have been some major changes and a lot more emphasis that we see on the use of state power to both protect data, but also to benefit from the economic use of data. So there is a lot of general discussion on the state's role in ensuring the protection of data or the proper exploitation of data. The state, according to the committee or the report, actually should take measures to make sure that the data of citizens is protected. There are new restrictions that are proposed on the transfer of data across borders, where the central government should be consulted again before any transfer to a third country is made, and so on. But there have been other changes that have also been more workmanlike, which have actually rationalized some of the problems or issues in the earlier version of the bill. So, for example, it limits the grounds on which firms or businesses can deny the right to port data, and says that you can only deny it on grounds of, say, technical feasibility and not anything else. There are more requirements on, say, the transparency of algorithms and how they are being used to make decisions. So companies actually have to provide details of how the algorithms are processing data. It strengthens the process of reporting data breaches, because now it says that all data breaches should be reported to the DPA, and companies should not be making the call on which breaches need to be reported. For significant data fiduciaries, there is much more increased compliance. They are now required to be registered. They have to conduct impact assessments, appoint data protection officers, also rationalizes some of the provisions on children's data processing, and actually increases the limitations on which the limitations that companies have to face, and basically says that children cannot be profiled or their online behavior cannot be tracked for any purpose whatsoever. But it also introduces certain other interesting new concepts. So for example, it says that all hardware and software products should be certified within India for adherence to privacy standards. And this is something completely new. And it's clearly coming from a security perspective. At the same time, it also talks about ideas that have a clear sense of indigenization or building domestic capability. For example, it talks about building a domestic alternative to the SWIFT payment system that about as per the committee's discussion, was subject to serious vulnerabilities in an incident a decade ago. And therefore, India should actually invest in building its own payment system as an alternative. It has also gone into other areas and expanded the role of the state, or recommended an expansion in the role of the state. So, for example, the one major change in the bill has been the change in the purview or scope of the bill. So the committee has actually recommended that the bill should look at not just personal data, but also non-personal data. So now it's a data protection bill, not a personal data protection bill. And it also recommends that the data protection authority set up under this bill should be empowered to investigate breaches of non-personal data also. And on the critical issue of surveillance, it actually does not make too many changes. It has imposed a minor procedural check, and it has basically said that any procedure under which the central government gives exemptions to its agencies have to be proportionate and meet the tests in the right to privacy judgment, the Puttaswamy judgment. But if you look at it from a substantive point of view, it's almost immaterial, because the government can arguably defend its existing procedure as meeting this threshold, and it's subject to debate. And this part was interesting because almost all the dissenting notes of the committee recommended a tightening of this provision, and recommended that the checks and balances in this section should be increased. But all of them were ignored. None of the suggestions were taken into consideration. Other places also where central government powers have been increased. For example, earlier there was a general provision in the bill which said that the DPA would be bound by the directions of the central government on questions of policy. Now the DPA will be bound by the directions of the central government on all issues and not just questions of policy. So these are some major philosophical shifts in or changes that reflect a philosophical shift in how the JPC has looked at the bill and the issues surrounding data protection. And it, in some sense, actually doubles down on the idea that we need to have this exercise of state power to harness the benefits of data and to protect citizens. And in the process, what we have done is to have a much more leeway given to the state, proposals that significantly increase a lot of state power, and most of the compliance is now going to be faced by the private sector. So if we look at how this debate started and how it's matured up till now, we look at the initiation of the discussion, which basically started with the idea of holding the state in check and to hold the state more accountable for any potential violations of privacy. And yet we are at this juncture where the state power under the bill has actually increased significantly. And most of the obligations are on the private sector. The state also has some obligations, and arguably some of them will be followed. But that's a question of debate. But the question is, how did we actually get to this position where the gap between the original context for the discussion and the close to final output or the current version of the bill is so large? So that's broadly how I would like to frame the issues for today's discussion.
Thank you, Anirudh. So perhaps now we can segue into our conversation and paying attention to your talk. And I'll just draw from that to raise a few questions to you. So the first question is that, see, this process started basically in the judiciary, with the impetus to make this bill, to constitute the committee to write the bill, started in the Aadhaar case. And then it moved to the executive branch, where it basically was for about a year and a half. When committee also was actually the executive branch process, but the ministry looked at it for 1.5 years, and then last 2 years it's been in the parliament. And so the first step, perhaps we could start with, is the way the judiciary addressed this issue, right? So, I mean, obviously a brief history is that this 5-judge bench on Aadhaar was looking at the legality of the Aadhaar law. And this question arose whether there is a fundamental right to privacy in India. the Indian Constitution. And there were 2, 6, and 8 judge benches which had actually ruled that there is no fundamental right to privacy in the. And then this doctrinal question was posed about whether this makes sense and should it be reviewed. And then this 9 judge bench was constituted to look at this question of whether there is a fundamental right to privacy. And they came back with, as you said, a judgment saying that there is a fundamental right to privacy. Article 14, 19, and 21 nexus basically guarantees a fundamental right to privacy. But that judgment, I mean, the different opinions in that judgment, but basically it wasn't responding to a particular set of facts. It was basically answering a question of doctrine about whether this such and such right can be read into the Indian Constitution or not. And they came back with an affirmative answer. Now, if you draw a line from that judgment to the bill that has been was drafted, revised, and then has to be revised again in the parliament, what do you think were the kind of broad guidance that you can draw from reading the Puttaswamy opinions on what kind of bill would actually be pass the muster as far as that judgment is concerned? Because any bill in law that is passed will have can be taken to the constitutional court and said, okay, there is can be basically appealed under the jurisdiction. So is there any specific kind of features of that judgment that you think can be brought up to inform this bill, or is it too broad and too open to allow for that?
Yeah, I think there are 2 or 3 big implications. The first one is the most obvious one, which is that the judgment meant that not only did we have a right to privacy, but also that it would have to be protected via a law. Right? Just the way the proceedings and the judgment panned out, it was fairly clear that the right to privacy would not be protected by specific judicial decisions on a case-by-case basis. We would have some kind of a overarching privacy law. So that was one implication, and it was not a given before the judgment happened that we would have a comprehensive economy-wide cross-sectoral data protection law. It happened because of the way the judgment panned out. The government made an assurance that there would be a data protection law, especially since there was so much controversy over the use of Aadhaar. So that was one, which is that it was almost decided that there was some kind of a overarching privacy law rather than privacy jurisprudence. So we jumped into the idea of a privacy law. The second was, what shape would the privacy law take? And here I think there are some implications of how the judgment was decided and written that had a bearing on how that would happen. One was, like you said, there were no petitioners and respondents whose rights were affected in this specific judgment in the 9-judge bench. There was the Aadhaar case that was going separately. But what this did was that this enabled the court to decide this case in a very different way. So in most judgments, there's an application of law to the facts of the case. And the law that comes into existence, the judgment, is through the application of the law to the facts of a case. And therefore, judges get a chance to actually deal with past cases and laws and see how they apply to this particular set of facts. And then they also have to deal with what are the constraining circumstances or what are the conflicting interests, say, of the government in that particular case. In this particular judgment, none of that happened. So the court had a lot more leeway in pronouncing or going into different aspects of the doctrinal idea of privacy, right? So the way the judgment is written, there are many, many very high-level pronouncements about what does privacy encapsulate, but almost nothing to identify how would it work out in a specific situation. And as a result of this, the judgment is not very specific. So it operates at a very high degree of principle that then potentially creates problems. So for example, one problem is that how do you balance conflicting interests, right? So for example, let us look at an issue like marital rape, right? There is a conflicting interest of the privacy of the family or the marital couple, but also the necessity to break down some aspects of that privacy to investigate whether coercion is being used. Right. So the judgment on the Puttaswamy judgment does not actually help us in thinking about this kind of a conflicting situation. And therefore, it does not help us think about harms or what are the kinds of harms that privacy rights are actually intended to protect very well. Right. The other is that because it operates at such a high degree of principle, it gives both kinds of signals that are confusing. So on the one hand, it actually states that citizens have a right of privacy against the state. On the other hand, it also states that, especially in the context of informational privacy, that the state has an obligation to protect privacy. Right? So in which specific context do we go in which direction? Those kinds of issues are not clear. And specifically in the case of informational privacy and data privacy, this judgment clearly says that there is a need for a law or a framework to protect privacy. It actually acknowledges the work of the JSK committee and says that as long as a law meets three tests, one is that there should be a valid law, there should be some kind of a necessity for having that law or for violating individual privacy under that law, and that there is a degree of proportionality in the measure that is used and the consequences of violating privacy, that any law that violates privacy would be constitutional. So it lays down this kind of a framework, and then it therefore shapes the way the data protection bill also comes into existence.
Right. Yeah. So I mean, obviously, it's a matter of debate whether whatever form the bill takes eventually when it becomes law, and if it is challenged in the court, whether the Puttaswamy judgment, the 9 judgment on privacy, has enough to be able to examine it critically, especially the kind of dilutions that have happened and broad exemption for state power. Now, so the second part of the committee, right? So there's a right privacy judgment. Just around that time, a committee is constituted, goes into the question of what kind of data protection law India should have, and it's an expert committee led by a retired Supreme Court judge, but it has civil servants, civil society persons, experts, and it spends about a year and comes up with a bill and a report. One thing that I've read the report as you have is that although it has a lot of ideation on what are the kind of practices in other countries that could be borrowed and what are the alternative formulations, there's not much by way of specific problem analysis. Like, what are the specific things that are going wrong? What are the specific harms that basically necessitate a law? And what are we responding to? So, do you think that could be one of the reasons why it's so easy to modify for the government to later reject parts of it and modify it according to its will, or is that too much, reading too much into the situation? Because the committee report has a lot of material on international best practices and alternative formulations, but not much by way of context-specific problems that need to be addressed.
Yeah, I would agree to that because it operates at a very high level of generality. And like you pointed out, I think we've pointed out in other writing also that one of the big issues with this report is that there was almost no empirical evidence collected on what are the specific privacy related issues taking place in India. So we have this anecdotal back and forth where people say Indians don't care about privacy and others say no, everyone cares about privacy. But again, that operates at a very high level of generality. In what contexts do Indians care about privacy? What are the burning data privacy related issues in India? None of that data was actually collected or presented, or at least it's not published in the report. And therefore, I think the approach the committee took was a very legalistic approach. So it looked at a lot of laws, it looked at a lot of best practices, it thought about innovative legal concepts like data fiduciaries, and it thought about what kind of legal frameworks would be good to have a data protection regime. But it was not suitably tailored, at least in my opinion, to the kinds of specific questions that are occurring in India. And I think when this debate got mingled with other ideas of data nationalism, economic exploitation of data or benefiting from Indian data within the borders of India, I think it was easy to import some of those ideas because this bill is such an overarching, comprehensive kind of legislation. It's trying to solve a whole gamut of privacy-related problems related to data. And therefore, it became, in my opinion, at least, much easier to import some of the other ideas into this bill. Because then you could argue, if you're having a legislation that's going to look at data from all possible perspectives, we should also be looking at it from the economic perspective, how to benefit from data, what are the prerogatives of the sovereign, and so on.
Right. So then from committee, it goes to the ministry. And you described a few major changes that happened. One, as you just mentioned, is this inclusion of non-personal data and the economic benefits of pricing open databases and forcing them to share non-personal data, anonymized data for various purposes. There was a committee that was set up to look into it. But the other major change that happens also is the discretion given to exempt processing by government. It's a big departure from what the committee had suggested. Let's examine these two to some extent, to the extent we can, in terms of the context in which this is happening. So one is that in the last few years, we see that government is seeing data as an economic opportunity. There's been reports on $1 trillion digital economy in India. That's one. The other is that government also is becoming a little bit more wary of big tech, global big tech operating in India, and basically wants more and more national champions, if I could say that, is to develop and compete with them. So perhaps it saw this law as an instrument to be used for those pursuits. So there's a political economy that is happening. The other, on the exemption of state processing, is, if you look at it's my perception of the way Indian regulatory state has developed, that I can't think of any context in which the state has regulated itself in a very effective way. So, what I mean is that you set up a regulatory authority by regulatory law, and it regulates effectively some other part of the state which is falling under its purview. So, I come from finance backgrounds. In banking, for example, Reserve Bank of India finds it very difficult to regulate public sector banks. It's much more difficult to actually impose any penalties that are effective, take any actions that actually have a consequential effect on their actions. So there's a long record of this problem, and maybe in other countries also it's there. I don't know. I don't have a comparative sense of it, but it is difficult for government, a regulator to effectively regulate parts of the state or state-owned enterprises and so on. So both of them have some kind of factors that were always there. These things were going on for years. Not just, it didn't start in the last year or 2 years, but had been going on since earlier. So, is it possible that the committee's draft that was there was anyway very unrealistic for the Indian context and was going to be diluted in some way or the other because of these factors?
Yeah, it's speculative to say that definitively, but I think there were some indications that it need not necessarily have been the case. So, for example, if the committee had identified some specific problems to solve in the context of data protection, specific harms, for example, there are some, right? We look at the issue of children's privacy and their use of social media platforms. Right? If there had been some other specific, more tailored, narrower problems that the committee had identified and it wanted to solve, we might not have been in this situation. Some amount of dilution, yes, I agree. This bill would have gone through a process where it was vetted by government, considerations of what the government should do and how it should operate, and how much accountability it should take on its own would be diluted once it goes through the government process. But if the committee had looked at slightly narrower and more specific problems, I think the objectives could have been better served. So, for example, the use of financial instruments by vulnerable populations or by the older demographic in India, or like I mentioned, the use of social media platforms by children and their likelihood of harms caused to them. And so if it had looked at specific issues, I think some of these mission creep that has happened in regard to this bill could have been avoided. But on the larger issue, yes, it is. It's definitely very difficult to regulate state power once it comes into existence, which is why we always see, every time you create a new law, there is some oversight mechanism that is created, and it happens not just in India; it happens in all countries, right? So in India, there will be some parliamentary oversight mechanism. Rules will have to be laid before Parliament. The budget will have to be authorized annually. But at the end of the day, like you said, these are all very imperfect oversight mechanisms. They are very limited in some sense. So the philosophy is that you should give the agency or regulator some independence, and then give it the leeway to actually perform the tasks that have been asked to. And this then creates that obvious problem that you have created a new agency or a new department or regulator or given a new sort of power, but the visibility on how that power is being used is always very limited. And that's what is going to happen even in the context of this data protection authority. We are creating a new regulator, we are giving it a lot of powers, and one is not imputing any sort of malice, but it's just the normal course of working of the data protection regulator. It will have to be very intrusive as a regulator. It will have to look at individual or business data in a much more intrusive way. And there will be fairly limited visibility on how it operates. And we've seen this in other contexts also in all countries. For example, the use of Pegasus by state governments across the world. Right? We have not seen any investigations or uh, uh, decisions or statements by national data protection authorities on this issue at all, right? Or by any ombudsman or oversight agency, right? And that just goes to the point of how the state regulates the state, because there is always some kind of exemption or bias or leeway given to another state agency.
Yeah, right. Now, I mean, moving to the parliament, right? 2 years of JPC process. So obviously, the executive modified the bill to protect some of the interests that it saw as, I mean, its legitimate interests. So it's given itself broad exemption powers in the bill that it drafted. But when it went to the parliament, there was at least a half a hope that it would get, I mean, strengthened. These provisions would be strengthened, and the grounds of exemptions would be narrowed down. The expansion into non-personal data and other areas might be, curtailed to some extent. But it seems that the JPC has gone further in this in this direction. There is much more power, and even as you were mentioning, I hadn't noticed this earlier, but that the power of the central government to give binding directions to the Data Protection Authority have been expanded. Earlier, it was only on policy ground, but now the Parliamentary Committee is saying that the executive should have much greater discretionary powers to, to instruct the entity which is Data Protection Authority. That's the creature of the Parliament, right? Parliament is creating Data Protection Authority. For it to give this, so and then as you said that there were so many dissents and they were not incorporated. It seems like it became basically a partisan kind of a process, and there wasn't that much application of consensus building process and all. But are you surprised by this kind of a turn in the Joint Parliamentary Committee comes out with a report where the executive gets its hand strengthened further?
Yeah, I mean, it's a little bit of a surprise considering the degree of uniformity with which there was dissent on one specific issue. On the other hand, it also reveals the fact that when you have a simple or an absolute simple majority in parliament and you are the executive, you can basically get your way, right? And I don't know if it's a question of hindsight or whether people should have been wiser to this fact. But the fact that there was a simple majority, the fact that there was a contentious issue of holding the state accountable over issue as sensitive as surveillance, where the stakes for the state are very high, it should have been probably considered a little bit more by the proponents of this bill. And I think the idea that we would be able to hold the state accountable under this very broad kind of data protection legislation, uh, it's clearly come out to be wrong, because the state has been able to resist that pressure even in the face of almost near uniform opposition to the provisions of the bill.
And just one more question for me before we move to the audience question is this. I mean, you touched upon it a little bit, but it would be good to hear a more comprehensive view on how the idea of data protection itself has shifted, or how the conceptualization of personal data has shifted over since the committee and court to the government and to the parliament. Like earlier, at least in the committee report, it seemed that the focus was very much on personal autonomy and uh, uh, development of personality, information privacy, for those purposes. And now, when I read the JPC report, the first few sections are all about data as an asset, economic value to be unlocked, and so on and so forth. And even in the government, when the non-personal data was added, the thrust was that, but the JPC report is much more on that. Do you think there is a kind of conceptual shift that has happened in the formulation itself of what personal data is for and how it should be conceptualized and thought of?
Yeah,
Why that?
there have been shifts in two areas. One is the idea of how privacy has to be protected, or how data has to be protected. Even in that, we are seeing a lot more paternalism in the provision or in the discussion of the JPC. So, for example, the JPC says that the government version of the bill said that the data that is stored within India can be transferred outside, subject to certain restrictions. The JPC says that even if you take that data outside and you want to transfer it to a third country, you need to first take the permission of the central government. So there are elements of more and more paternalism, or the idea that it is the state's job to protect the data of the individual, rather than creating mechanisms through which the individual can protect his or her privacy. So on that itself, there has been some kind of a shift, maybe more subtle than others. But on the other, yes, I think there has been a lot more discussion on the value of data as an economic asset and how that should be exploited. And I think there again, we are seeing that the focus is not on how individuals can maximize the value of their data, but what the government can do to make sure that the value of that data is exploited and used to the benefit of the country. So, I mean, there are different ways of looking at the same problem, but they do have one critical difference, in the sense that in one, the individual and the markets are in more control, whereas in the other, it is state power which is being used to create or shape these markets. And there's been a significant shift. So when we look at the whole discussion on non-personal data and how you can actually derive benefits from non-personal data, that is basically anonymized personal data, or when we are looking at, say, building infrastructure for, say, the collection of consent that can be used to lower entry barriers in the finance and so on and so forth. We see a lot of proposals where the state has to do something to actually enable those markets. And one element of that is also protectionism. So it's also coming from this larger idea that the state has to do something proactive. Otherwise, we will not be able to maximize the value of our data as a country.
Right. And at some point, maybe this year or later this year, or some version of this will become law, and then the conversation will move towards what the Data Protection Authority will do and how it will operate, and the politics of the regulatory politics of the authority will basically shape to the extent the outcomes from this bill will flow and what kind of outcomes will flow. So the politics will continue, and so far we've only taken stock of what's happened till now, and that too only briefly. There's a lot going on. Now I'll move to some of the questions that you got from the audience. And one question is from Prakash. How would the localization of data affect the social media platforms like Facebook or Twitter? What has been their reaction to these? Maybe the second part, the reaction in recount. but what would be the effect uh, based on the present formulation of the localization requirement?
So localization is definitely going to affect most of the large social media companies because they are currently storing data in servers outside India. So they will have to, if localization is introduced, they will have to either shift their data to servers in India, or they will have to enter into agreements that will enable them to take data outside India, but then they'll only be able to take certain data outside India. And the Indian bill also creates this distinction between personal data, sensitive personal data, critical personal data. So they'll have to start differentiating and storing them differently, processing them differently, implement different kinds of security systems for each kind of data. So it's a compliance cost. The other difference is, of course, that the law enforcement establishment hopes for, which is that getting access to data of Indian citizens will become a little easier. Because right now, since this data is stored outside India, law enforcement agencies have to go through a very cumbersome diplomatic procedure to get access to this data. And at least according to them, this hampers the efficacy with which they can actually investigate crimes or try and surveil terror networks and so on. And the hope is that if you move the servers to India, that access will become easier. But that proposition is debatable because there is actual conflict between the laws of different countries, but that's the hope. So these are some of the ways in which localization will impact social media companies.
There's a question from Satya Mitran. Would you have any specific recommendation on what the wording of the bill should be, or what anyone in the government should do to make the DPA more effective? Right, After
Yeah, but it requires a very long answer. I think broadly, the current version of the bill does some things well, which is it has given the power to exempt a lot of manual processing and small scale use of data. So small entities below a particular threshold will be exempted from the ambit of this bill, which is very important from the context of India's economy and potential to exploit data and benefit from it, because most entities, companies in India are small scale entities. So I think we should have a provision, or we should be able to exempt those kinds of things. The other is a greater focus on identifiable harms, which is what we were discussing at the beginning of this session, which is that the bill should actually list very clearly what are the harms that the bill is trying to remedy and solve. There is currently a definition of harms which is very wide and expansive. There are, I think, a list of 12 or 13 harms, and it is used as a reference point in only a few provisions of the bill. But it should be much more clearer. There should be a much greater focus on what are the harms. We were discussing specifics like the vulnerability of children or older segments of the population and so on. I think those are the kinds of provisions that should be in the bill.
Thank you. There's one more question from Prakash. Is there any specific agency for grievance redressal for breaching the data privacy laws, or suggestions for it? Any state and private players, social media, e-commerce?
So under the bill, the Data Protection Authority will have to perform this role. They will have to perform a grievance redress function. They'll have to set up the system to handle complaints from people whose rights under the bill have been violated or who faced a problem. And they will there also be in charge of enforcing this law. They'll have to talk to the companies or the businesses who've actually violated these laws and go after them. And that's the mechanism. Currently, it's mostly sectoral regulators. So for example, in the financial sector, the banking sector, RBI will handle these complaints, and in the securities market, SEBI will handle these complaints.
Yeah, just to add, so the bill has two layers of grievance redress. One is that the data fiduciary themselves are supposed to provide a grievance redress mechanism. And if there's a significant data breach, then they need to appoint a data protection officer, and they will be the first port of call for grievance redress. And if there is some compensation to be sought, so if you've suffered a harm because of the breach of this law, and you seek a compensation as a grievance redress, then the data protection authority has to appoint adjudicating officers to whom you can go and seek redress in the form of compensation for whatever grievance that you've suffered. So these are the two levels in which it is currently designed. And then eventually they may develop an ombudsman kind of structure in which the grievances will go and be addressed. Okay, now I'm moving to other questions and comments. Yeah. Yeah, Marcel Floor has a comment and question. You mentioned the EU GDPR putting consent management central and a balance between individual rights and state control, essentials of mature democracy. So societal and moral values are put over economic or security considerations. Also, in the GDPR is a provision that can serve as an entry key to the European data market. Would you think that the present JPC proposal would qualify under the so-called adequacy provision? That's a very important question. It's obviously a matter of opinion, and as the EU-Japan agreement and other agreements show that adequacy is not a one-off thing. It can evolve over time. You can get time to be able to meet the adequacy requirement. But as is, would it, if suppose all the JPC recommendations are incorporated into the bill, would they would be would we meet the adequacy requirement?
Going by what we've read so far, the exemptions given to the state or the power to give exemptions that are in the bill, they would create a definite problem under the adequacy requirements, because the EU does require a very high degree of checks and balances when it comes to government use of data as well, in addition to private use of data. And I think the JSK version of the bill was much more amenable to this problem. It would have, I think, been much easier to meet that adequacy requirement. But adequacy is not the only way in which Indian companies can collect European data. You can also do that through contractual arrangements and so on. The problem, of course, is that these contractual arrangements also need to meet a certain threshold. So European courts, for example, have held that the US-EU agreement on transfer of data was not compliant with the GDPR because the level of security afforded there was not adequate, and did not meet the standards of the GDPR. So these are the problems, and I think to meet that adequacy requirement, we will have to take a serious look at the provisions that give exemptions to the government.
Right. So Brinda has a question about, does the current bill cover paper as well as digital data privacy? If yes, then how can the current form of bill regulate data on paper records? Also, a specific privacy harm is a harm caused when converting paper to digital. As per you, how can that be worked on?
So on the first one, the JPC version of the bill at least says that this bill would cover automated processing. So it's not even, so manual collection or maintenance of data is exempt. And also if you're just maintaining for example, a spreadsheet or some kind of a Word document in which you have data of certain individuals, that is also exempt unless you are using it in an or using that for some kind of a automated decision making, or if you're running a macro or some kind of a tool to automate that process of data collection and deriving insights from it. So at least if you go by the literal wording of the JPC's proposal, the scope is limited only to firms that do automated processing. And that's a good thing in India's context, because we actually need to ensure that a lot of the compliance burden does not fall on very small entities who are actually not using these kinds of tools. I did not fully understand the second part of the question, where you ask whether a specific privacy harm is a harm caused when converting paper to digital. You're right, there could be chances of data leakage or errors that happen. In that case, the consumer would have the right to request an access to their data and to be able to correct that, so they'd be able to ask the company to furnish their data that is collected by them, and then to demand that any errors or omissions that have crept in can be corrected.
Yeah, so the bill that was introduced included, obviously there were exemptions for automated processing for very small entities, unless there were automated processing for small entities that were doing non-automated kind of processing. So, but the JPC you're saying has actually exempt all non-automated, all processing outside of automated processing. Suggested that. Okay. That's a big change in the scope of the bill.
Yeah, the earlier wording was manual and they have changed it to non-automated. So it's a very clear change in approach.
One more question we've got on YouTube. It's a broad question, take it as you want. How could India boost the innovation and competition in data security while not compromising the data privacy of our citizens?
So I think India is already providing a lot of competition for data security because we actually suffer a lot of data insecurity. If you look at global reports, we are amongst one of the most vulnerable countries in terms of data security. We suffer among the highest number of data security breaches, attacks on databases and so on. So this is something that markets are already coping with and already providing services for. If you look at market reports, data security companies in India are actually, it's projected that they'll grow by, significant percentages in the next few years, just because of the vulnerability of Indian data systems. So that's, I think, one problem that the market is also solving on its own. There is a clear problem and people are providing services to make sure that data is much more secure in India now.
So these were the questions from the audience. So if you want to give a last word on the evolving politics of data protection, please do. There's one more question that just come up. I'll just read it out. Would it be possible to briefly relook the earlier wording of manual and the current version of non-automated in the bill? Yeah, I don't know whether we need to answer that question. Yeah, we can look at that.
Yeah, I think to close, I would just say, and this is something we've realized over a period of time, that what we are missing is the discussion of specific problems in the privacy discussion that need to be solved. And I think one of the mistakes that we've made is that we've thought of privacy as an end in itself, rather than trying to see what does privacy and data protection actually help you solve, what kinds of harms is it preventing. And therefore, by taking this larger, more generalized kind of approach, we've actually fallen prey to different kinds of interests, different kinds of objectives that have come into this debate. And as a result, we've ended very ironically at this juncture where we set out trying to hold the state accountable, but at the end of the day, most of the accountability is being imposed on private firms, private businesses. And the state is actually getting more powers, and the original aim of trying to hold the state in check is still, beyond our grasp.
So on that note, thank you everyone for joining us today. We do these seminars usually once or twice every month on some or the other political economy issue. Please join us again in the future editions of this. Thank you. Thank you, Anirudh.
Thank you. Thanks, Suyash.